Harold Bonnell, it's case number 2513676 FH. He's here for sentencing. Prosecution and defense was the pre-sentence investigation report timely made available to you.
Yes, Your Honor.
It was, Judge.
And Mr. Price, I'll give you the opportunity to read the report and discuss it with your client.
I have, Judge.
Do you have any additions, corrections, or challenges?
I do have a couple of things, Judge. On page 1 of the actual pre-sentence investigation, after the first 2 introductory pages of the second paragraph, it talks about his pending felony charges in Wexford County. He actually pled to CSC third, Judge. It does say second, but he pled to third degree there.
Hang on just a sec.
Yeah, it's on the first page, Judge.
Right, I'm just looking at what it shows in the rest of the pre-sentence report. So, all right. So entry number 11 of 11 shows that his final charge was criminal sexual conduct in the second degree. You're indicating that should be third degree.
Yes, Judge, and I actually have the order of the court plea if the court wants to review it. That indicates. Yeah. I showed it to the prosecutor, Judge, and he actually does indicate that it was third, not second.
Okay, we'll make that change both for entry number 11 of 11 under the criminal history, and we'll also change it on page 1 of the CFJ 284. Any other additions, corrections, or challenges, Mr. Price?
Judge, it has to do with the sentencing guidelines. On page 1 of the sentencing information report. OV4 is psychological injury to a victim that was scored 10 points. I didn't have any information that there was any counseling, or I don't know whether the nature of the offense would give rise to any counseling, but that was scored as OV10. So absent that, Judge would ask the court to score that as 0.
All right, hang on just a sec here. So the victim's impact statement indicates that it's been attached to this court for its review, but I don't have that.
Okay.
You have the victim's impact statement?
I do, Your Honor. I can show Mr. Krysak that it indicates that the victim is in counseling.
You want me to bring it to you, Your Honor?
Yes, please.
Oh, I apologize. Said you don't have it.
I don't have it.
I am sorry, Your Honor. I misheard you.
So in this
I hadn't
case,
seen that. I withdraw, Judge.
okay,
I hadn't seen that.
all right. So, offense variable 10 is appropriately scored. I'm sorry, offense variable 4 is appropriately scored at 10 points. Any other additions, corrections, or challenges?
On OV10, Judge, that was scored 15 points for predatory conduct. I think this is just a one-time action. So I think it should be scored 10 because of her age and the domestic relationship between Mr. Bennell and the alleged victim in the case, Judge. So instead of 15, I would ask a score of 10 on OV10.
Ms. Robinson, what is your argument as to whether the defendant engaged in pre-offense conduct directed at a victim in this case?
Your Honor, I believe that the information and the continued relationship between the two of them, I understand there was one we had here, one specific instance, but it I believe that most of the pre-offense contact occurred, according to the report that we have, prior to the Cadillac offense up in Wexford. Our offense was before that. My office, we had it scored at 10 points as well, due to the domestic relationship and her youth or agedness, but that was based on the information we had, did not include, I didn't have enough information to believe that it was appropriate at the time of scoring to rate it as predatory for ours. I do believe it would be predatory for Wexford's, but that occurred after ours.
Okay, so you agree that offense variable 10 would be scored at 10 points?
Yes, Your Honor.
Okay. Any other additions, corrections, or challenges, Mr. Prysock?
Judge, on OV11, penetration, there was no penetration in our case. There was in the Wexford case, but that occurred after this case. So there was no penetration. That was scored at 25 points. And I discussed that with Ms. Robinson. And I believe she was in agreement that that should be 0 because there was no penetration. However, I think that OV13 that was scored 0, Ms. Robinson can make her own argument, but she pointed out that that should be, says it should be 25. And I believe that requires 3 or more crimes against a person, but I think we only have 2 crimes against a person.
Well, let's take it one at a time.
All right, one at a time. I'm sorry, Judge.
So offense variable-
11, there was no penetration, so we're asking for 0 there.
And Ms. Robinson, you agree that for that variable, we score just the conduct involving the sentencing offense?
Yes, Your Honor, but the conduct just involving this offense, there was no penetration for ours, so that should be 0.
All right. So any other additions, corrections, or challenges that you have to?
Well, as I said, Judge, after I talked with Ms. Robinson, then she brought up that she had scored OV13 as 25, I think you said, Rachel? Or no?
I had OV13 at 25, Your Honor.
And the department has it at 0 and I have it at 0, so.
Okay, so we originally talked about offense variable number 12. That's contemporaneous felonious criminal acts, so that would be within 24 hours. I don't have a time frame that I can decipher whether there was any offenses within 24 hours. So, and it sounds like, Ms. Robinson, that you're not asking to score offense variable 12, is that correct?
No, Your Honor. I believe that the information we had was that it was 2 days later, so I don't believe that we had any for OB 12.
Okay, so then we turn to offense variable number 13, continuing pattern of criminal behavior. And does 25 points for the offense was part of a felonious criminal activity involving 3 or more crimes against a person apply in this case, in your opinion, Ms. Robinson?
Yes, I believe that it does, Your Honor.
Mr. Fryside?
I think not, Judge, because he was convicted here of 1 count of CSC, and he was convicted of 1 count in Wexford, and all of the other counts were dismissed. So I believe we only have 2 contemporaneous crimes, not 3.
Ms. Robinson?
Your Honor, pursuant to MCL 777.43, parents 2, parents A, all crimes are to be included without regard as to whether they resulted in a conviction.
Thank you. So we'll score 25 points for offense variable number 13.
I think that puts OB at 50, I think.
Correct.
I don't think that's going to change. Yeah.
I guess before we go there, Ms. Robinson, do you have any other challenges to the advisory guidelines?
No, Your Honor, no further challenges.
All right, so we've got prior record variable level C. We've got offense variable at 50 points, which puts us
2 to 17.
0 to 25 with the habitual offender third.
0 to 25. Yeah. Okay. Got it.
All right. Any other additions, corrections, or challenges?
No, Judge.
Anything that you want to say on his behalf?
Well, Judge, he brings up a couple of points. He believes that on the record, the habitual offender third was dropped. I did have a no contest plea that we had filed. That it looks like it was 4th degree with a habitual third, but Harold thinks that it was not a plea on the habitual third. And so that's the only thing I have in my notes, was that it was the no contest plea CSC with a habitual third. So possibly court could clarify that for Mr.
So what my notes indicate was on November 4th, the offer was plea as charged, which was to more serious offense of criminal sexual conduct in the 2nd degree.
Yes, sir.
And then there was dismissing the habitual offender at that point. Then there was some further discussion, and I think they determined that any penetration did not occur here. That was in another county. So then at the next court date, which was fairly still in November, the plea there was criminal sexual conduct 4, plea 2, habitual offender. So that's what my notes indicate. Ms. Robinson, is that what you think as well?
Your Honor, yes, my notes indicate that the offer was the CSC third with the habitual offender third offense.
4th.
Third offense.
Yeah, third. CSC 4th with a 3rd.
CSC, excuse me, yes, CSC 4th with a third offense.
And I think that was a confusion, Judge, was that first plea was a 2nd without the habitual, and then our subsequent plea was 4th with the habitual. So I think that would clear that up.
Yes. Anything else?
I just call the court's attention that when Mr. Bonnell was here and he did enter his plea, the court, I believe, had indicated that the court would consider the county jail sentence for Mr. Bonnell in the term of probation. I think that falls within the guidelines. So we'd ask the court to consider the county sentence for Harold, concurrent with Wexford. I think he has his sentencing coming up in Wexford. And when do you think it is? I think it's in March, Judge. I talked to his attorney up there. So I believe that sentence there is going to be probably more than what we have here because it's a more serious offense. But we're asking the court to consider county time for Mr. Bennett.
So I did not indicate to Mr. Bennell that I was considering a county sentence in terms of any sort of Cobb's agreement whatsoever. What I most likely said that it would be sentence consistent with the advisory guidelines. And if the court sentenced him to a county jail sentence, then he would be consenting to a term of probation.
Yes, sir.
But given
That was my recollection. That wasn't his.
I didn't rule it out, but I didn't say I'm going to, he's going to get a county
No,
sentence.
no, I didn't mean to give the court that impression that you committed to it.
All right. So, Mr. Bennell, have you had the opportunity to read the report and discuss it with Mr. Prysock?
Okay.
Do you have any additions, corrections, or challenges?
You already put those on there.
Okay. Is there anything that you want the court to consider?
Since I've been in incarceration, my daughter I missed out on my daughter's surgery. That's 9 months old, and I missed out on my son being born the 13th. And I just want to let the courts consider that if I did get county time or probation, that would show, that I'm not a bad person. And before I went to jail, I did a CSE class for detective services. And I gave the report to Prysock, and I passed that. And I just, I'm not some bad person or anything. I understand that what I did was wrong, and I really feel bad about it. And, I don't want to be put away and not be able to be in my kids' life. I have 11 kids, and I had custody of my 9-year-old daughter. So I'm asking the court for, a little leniency, and, I'm already getting sentenced up there in March, and their guidelines are 15 to 24 months. So I'm just asking, just to show you and prove to you that I'm not this evil person, and I'm not that person. I'm not a career criminal. I mean, my last felonies were 25 years ago. I haven't been in trouble in 25 years. Haven't done nothing wrong besides, I'm at this. And like I said, I admitted that it was wrong. And, I'm missing out on a lot of important things in my life. And I understand that's worse than, doing prison or jail, not being in my daughter's life with brain surgery and seeing my son be born. I haven't even got to see my son. So I'm asking, to consider that and let me prove to you that I'm not this bad person, and whatever I have to do, I will do, and I will show you everything.
That's one of those things where it's hard to separate, decent people who do bad things, and at what point do they cross a line where they become a bad person? And to me, I don't really have to make that distinction, because to me, it's almost the same, that a person, you, did bad things. I mean, I can't imagine what was going through your mind, or even what's going through your mind today, to think that you're not a bad person. You raped a young person. You're 48 years old. You raped a young girl. You ruined her life. And how you can sit there and think that you're not a bad person and you want this court to feel bad for you that you haven't seen your daughter or haven't seen your son. I mean, I feel bad for your family. I don't feel bad for you one bit because you earned this. These are the consequences of your action. You shouldn't be around any kids.
I wasn't.
You're
I
a
didn't rape her.
rapist.
I did
You're a
not.
child molester.
I did not rape her. I did not rape her.
Okay, well then let's let you withdraw your plea. See what happens. See what a jury thinks. Is that what you want to do?
I'm just,
If you have sex with someone who's not of the age to consent, it's rape.
let's look here.
So look, you don't think you did anything wrong? You can withdraw your plea.
Well, you said I had sex with her here. I didn't have sex.
I didn't say you had sex with her here.
You said I raped her and I never.
You did. You did it in Wexford County.
I never raped her.
All right. I guess we can agree to disagree. So, Ms. Robinson, any additions, corrections, or challenges?
No, Your Honor, nothing in addition to what we've already put on.
All right. Anything that you want the court to consider?
Your Honor, I'd like to put on the record that family of the victim is here. I believe the victim is with them. They have indicated they don't wish to speak, but I would like to just make an argument on their behalf to the court that this isn't even a crime that just affected one person. It impacted the family, and that is because the child that the defendant has not seen is the nephew of the victim. The defendant had a partner, and what ultimately it came down to is whether or not they were legally married at the time. But either way, this was her older sister's partner, her older sister's, baby's father, and he took advantage of her and had sex with her. And the fact that he can sit here today and try to minimize what he did, it's really difficult for me to listen to. I think it's probably difficult for them to listen to. I think it shows that whatever metric somebody used to say that he quote unquote passed a sex offender class, that metric is broken. Because if he does not take responsibility for what he did, he believes that it should be minimized, that he is a danger. He is somebody who is placing everybody at risk. And he says he hasn't been in trouble in 15 years or in 25 years. So I understand maybe he doesn't have any felony convictions in that long, but he has a domestic violence conviction from 2015. So maybe he doesn't think that counts as being in trouble. He's dangerous. He is somebody who not only, took advantage of a young girl here, he then went elsewhere with her up to, I believe, his home up in Wexford and escalated that behavior. He's dangerous. I would ask this court to sentence him to the top of the guidelines. I believe that he has shown through his actions in here and then the continued actions in Wexford, as well as his comments here today, that he's dangerous and that there's nothing else that is going to keep anybody safe except keeping him incarcerated. Thank you, Your Honor.
Yes, the court finds that the advisory guidelines would suggest a sentence between 0 and 25 months. The court's going to exercise my discretion so that it's consistent with the advisory guidelines, consistent with the plea agreement in this case. It'd be the sentence of the court that this defendant served 25 months on the minimum to a maximum of 4 years with the Michigan Department of Corrections. He's to have no contact with the victim in this case. There's a $130 Crime Victims' Rights Fund fee, a $60 DNA fee, a $68 state cost assessment. He needs to register as a sex offender. Mr. Bennell, if this crime had a higher maximum penalty and if the advisory guidelines were higher, you would get a higher sentence. You take no responsibility for your actions. You think what you did was okay, justified. You want to quibble about what's rape or not rape. Somebody cannot consent if they're not of a certain age. And I can just tell you that if you continue with that attitude and belief in the Michigan Department of Corrections, you will not make parole, which would be fine with me. Right application for the period of conviction sentence, court attorney, appeal, request from lawyer must be filed with the court within 42 days. And the court would direct the financial assessments would be collected through the Alameda County and parole process.
I didn't take that.
Thank you,
Good luck to you.